when we think about your traditional custody, what we're thinking about is, okay, you're going to court, you're getting a custody order, it's one parent, it's another parent. But we also have a lot of times where, based on circumstances or factors out of the party's control, we have grandparents jumping into cases. Although that's been happening for quite some time, I would argue. I think that's still going to be our non quote unquote traditional modern type family situation.
I think, and if I can chime in here
yeah,
too.
Please do.
Every family lawyer has had this experience where you meet with your client, and at some point during the sort of, nascent stages of that attorney-client relationship, you suddenly realize that your client's not driving the bus. It's a grandmother, usually. They're paying the bills, and they want to be included in all of the emails. They want to be in on the phone calls. They want to be in on the meetings. And you're having conversations with your client about what this does to attorney-client privilege, et cetera, et cetera. My sense is that we're seeing more of this because I think we're seeing more young people, and by young people, I'm talking about people in their early 20s, who are having children who are not able to live, who can't afford their own place. They're still living with their parents. And so, to Kellie's point about sort of non-traditional relationships where, people are having children who are choosing not to get married, people who are having children who are not in intact relationships are frequently living with a parent or with parents.
Right.
And so, the custody and support matters that we're called upon to handle really end up sort of involving this much more complicated constellation of family. And it can be a challenge for a lawyer to kind of really figure out who the client is and more appropriately, who the client is not.
Right, right.
The other scenario that I've come across in some counties is, unfortunately, this rise of opioid addiction. And you have, for instance, I'm thinking of one case in particular, mother was incarcerated as a result of her drug addiction. She was caught stealing or something like that in order to buy drugs. So she was incarcerated. Father was in rehab this time. So previous, he had been incarcerated, but at this time, he was in rehab. They have 3 children. Who takes the children? Do they go into foster care when there's a grandmother or grandparents rather who are willing to step up and actually help out in this situation? So that's exactly what happened in this case. The grandparents of the father, so paternal grandparents, actually came to me, retained my services in order to file as interveners in the case, frankly, and assert some custodial rights and gain custody of the children while the parents were indisposed, if you will. And so once the mother was released from prison and father was discharged from rehab, they were able to resume some type of supervised visits, meaning the parents, grandparents continue to retain custody over the children until such time as the courts deemed it appropriate for the parents to then resume custody of the children. So that's something that I'm seeing quite often as a result of opioid.
I've had 2 of those cases in the last 2 years and didn't have a single one in the prior 24 years. So yeah, they're happening. It creates these non-traditional families, if you will, also create challenges for attorneys because frequently you'll have grandparent and a parent come to you and their interests are aligned at that point in time. And sometimes those alignments fall apart down the road. The parent who was perfectly willing and happy to have, grandma take care of the kid because she was going to rehab or there was the possibility of incarceration associated with that, gets out, thinks that she has her act together and is ready to assume or reassume responsibility for that child. And now all of a sudden, lo and behold, grandma doesn't agree. And guess what? You might not be able to represent either of them now at this point. So be careful be careful who you meet with up front and explain to grandma and parent that, while you can certainly work with both of them at the moment, if their interests should diverge down the road, they're likely going to have to go find new lawyers, both of them.
Or the other scenario where grandma, and we're saying grandma, heck, it could be grandpa as well, or
It's never
grandparents.
grandpa.
I know, but I don't want to be
Or
sexist.
non-traditionally, it
Oh,
could be
there you
some
go.
additional third
That's
party
right.
who's not grandpa or grandma, which
However,
then adds a new layer of, does that person even have standing to jump in the case and sue?
true, but I'm not even going to go there yet. So I'm sticking with the grandparents. So you have grandparents who were serving as childcare while the parents were going to work or whatever the case may be. At some point in time, grandmother and daughter have a falling out. Grandma doesn't necessarily agree with the way that mother has been living her life. They have a falling out. And so mother now says, you know what, I don't want you to see the children anymore. I don't want you to see the children anymore. And now stops grandma from having any type of relationship with the children. So that bond that was once created with the grandchildren is now being jeopardized. It's now being jeopardized as a result of the biological mother saying, I don't want grandma to any longer have a relationship with the grandkids just because they had a falling out.
Yeah.
And so the courts will treat that appropriately as well. And really what they'll say is, well, how do the biological parents feel about the grandparents continuing contact with the children? We understand that grandma has been involved for X amount of years and has actually bonded with the grandchildren. And now for whatever reason, mom is saying no, but is that enough to permit grandma to have standing?
Right. To our point about custody, I mean, some of the other traditional custody, situations we think of, and I just had this case, I represented a father in a case, it was a Carbon County case, but it ended up going to trial, and he was convinced, absolutely convinced, that no matter what I did, that the court was always going to defer to mother and be favorable to mother, and it didn't matter what mother did that was inappropriate, and it didn't matter what father did that was beneficial to the child and the custodial situation. He was just absolutely convinced that mothers had a leg up. And what I've been trying to tell my clients, and I'm sure this is county specific, different counties, you might get a different sense of things, but I am of a mind that there's no preference. Everybody's going in on equal footing. And again, that equal footing might become unequal if someone's the primary custodian and they've had the child for significant periods of time. Okay, well, if that happens to be mom and your client says, well, mom has a preference. Well, it's not because she's mom, it's because she's been the primary custodian. And that's one of the factors we consider.
Let me interrupt you here. Do you still believe that's the case with very young children? Because I'm not going to mention counties, judges, hearing officers by name here, but I can certainly think of at least a couple off the top of my head where the parties are not on equal footing if it's a very young child. And I'm talking, infants and young toddlers, maybe under the age of 3. And I still don't think fathers are on equal footing in those scenarios.
Yeah.
I agree.
Yeah, and I had one recently where the child was 6 months old, and the position was, well, you can't remove this child from
Mother.
Right. So legally, I do not believe there is a preference, but in practice, Alan's right. In practice, that may not be what's happening.
Well,
I don't
look, the back door is always best interest of the minor child.
Mm-hmm.
So long as, if you've got a minor child that's breastfeeding, boom, best interest of the minor child is not to be separated from the parent that's doing the breastfeeding and expressing breast milk and being able to freeze it, et cetera, is likely not going to be a sufficient accommodation to allow dad to be the primary custodian of that child. And so I just think that, idealism is going to run smack into the brick wall of reality every time where that's concerned. most of the fathers that I've dealt with as clients recognize that. I mean, and once in a while you get someone who's just pig-headed and just insists that, you know, they can make that work. And of course they can't. I
There's only
couldn't,
so many bottles you can fill and send with the child
Right.
over to dad's house for overnights. I mean, let's just be realistic about that. So as a result of that, I do tend to see that is the trend. We're talking about very young children.
I do think that, and I think everyone who's attending here today, who's been practicing for more than, 10 years, for example, can see that I think dads are more likely to get a receptive hearing from judges and family courts with respect to increased custodial time up to and including shared custody. The cookie cutter, you're a dad, you get every other weekend and a Wednesday dinner visit is no longer the norm. And it was 26 years ago when I started practicing. That's what you got. And that's not the case anymore. And I think that's due to a lot of changes in the world, not least of which is, the makeup of our judiciary. Our judges look different than they did 25 years ago, and their experiences are different, and what they bring to the bench is different.
And maybe exposures to new and different and changing family structures are changing what they see and what they're ruling on.
I agree.